The definition which we had discussed is a very general definition, which is the common meaning of the word promoter. But now in the Companies Act 2013, Section 2, Clause 69 has been inserted since day one, that is 1st April 2014. Now it legally defines who shall be named, who shall be the promoter legally. So the legal definition is promoter means a person. Now the word is being used, first word has been used, means. That means it does not include anything except these 3 points. The company law will only, that is an exhaustive or exclusive definition, which starts from means. That means the company law only means these 3 types of persons as promoter, nothing else. Right? There is a difference between an exhaustive definition and an inclusive definition. Where the word includes is being referred, so the promoter includes, anything includes means the general meaning also, and specifically whatsoever points have been given in the definition. But here the word means have been mentioned. So in the word means, that means only 3 types of people will be deemed as promoters. Now it means a person. Now what is special about the word person? Person includes both natural person and artificial person. So any person who has been named as such means as promoter in the prospectus. Now what is a prospectus? It is a document through which the company raises funds. ये जो IPO, FPO or so in that prospectus, you need to mention the name of promoters mandatorily as per SEBI. The SEBI guidelines clearly tells us that we need to name the name of the persons who are the promoters of the company, or who are identified as such, identified as promoters by the company in annual return. See, when the public issue comes, the prospectus are issued and prospectus are launched. But over the time of years, every single year, the company needs to file an annual return in MGT 7 within 60 days of the annual general meeting. So it is a one-time activity, or it is a conditional activity ki whenever the company comes with the public issue, the prospectus will be having the name of the promoter, that is a present promoter. But over the year, that is every year, who is the promoter of the company, it may change. Promoters are basically those persons who have the ultimate control over the company. The promoters might get changed year after year. It is not only such that the initial members who had contributed to the incorporation are the promoters. It is not like that. Promoters name, promoters group may change year after year as specified under annual return under MGT 7. Apart from it, the persons who have the ultimate control over the affairs of the company, whether directly, that is, they are having the share capital, whether they are the ultimate directors of the company, or otherwise, or any other agreement, otherwise includes any other agreement through which they possess the control over the affairs of the company, either through themselves or indirectly. Normally, indirectly, we had discussed holding and subsidiary relation, where you, together with your subsidiary, controls another company that is also your deemed subsidiary. Next is in whose instruction, with whose instructions, in accordance with whose instructions or directions or advice the board of a company is accustomed to act. Normally, the people don't come into the front of the company, they control the company from the back. These persons are known as shadow directors or shadow promoters. But anyhow, the company law comes into picture when it defines the word promoter as any person, if the board is accustomed to act according to your direction by any agreement. Is there any tuning between such as such? So those persons will also be will be treated as promoter for the company law purpose. Provided that if you are giving any professional advice, if you are an advocate, if you are a practicing company secretary, chartered accountant, CMA, who is just giving the professional advice, and in your professional advice, the directors are acting on your professional advice, that doesn't mean that you will be the promoter of the company. Apart from giving the professional services, if there is any person behind who is giving the directions, who, if he is giving any advice, and the board is accustomed to act according to those directions and advice, that person will be named. They will be meant as promoter of the company. So if your name is written in the prospectus or annual return of, or if you are having a control as a director or shareholder or otherwise in pursuance of any agreement, or if you are a shadow director, will be treated as the promoter of the company under 2 clause 69. Now, what is the legal position of the promoter? The promoter will not be an agent because the company is not in existence, no principal, no agent. The promoter is not a trustee because for the trustee, the trust has to be there, but the promoter is doing the pre-incorporation agreements. The company is not right now a legal entity in the eyes of law. The company is not in existence at the promotion stage. Thus, the promoter only stands in the fiduciary relation, that is a position of trust, agency plus trust to the company, and of course to the persons जिन लोगों से आपने शेयर होल्डर्स बनने का प्रॉमिस लिया है, दैट इज जिन लोगों से पैसे लिए हैं या आप लेने वाले हैं. So the promoters acts as the agent to those persons and the trustees to those entities suo motu on its own motion. It is not as per law, but it is deemed to be the agent and trustee. Right? So what are the duties of promoters? Two major duties have been given under company law. First is basically one major duty. The promoters cannot make secret profits on the assets acquired by them in the course of course, incorporation. Or in the course of incorporation, if they are entering into pre-incorporation contracts, they are not allowed to make secret profits. See, what is not allowed is secret profits. Is making profit allowed? Yes, you can disclose that you have purchased so and so land or building or whatever asset for the incorporation of company. Say for example, the cost of the land is 20 lakhs. You have purchased it in the name of the company for 22 lakhs and 2 lakh is your profit. If you have disclosed the fact while making pre-incorporation contracts to the, of course, to the proposed company and to the shareholders of the company, then that is allowed. What is prohibited is not to disclose the profit and you are secretly making profit out of the agreements made on behalf of the proposed company. So making of profits is allowed, making of secret profits are prohibited by the promoters.